In this lesson, we will begin our discussion on the natural law theory. Now, at the very outset, there are three fundamental jurists or academics who are of seminal importance to natural law, namely Aristotle, Socrates, and Plato. First and foremost, we need to understand the thinking behind natural law. Now, this could be considered as one of the fundamental or the inception points of proper legal jurisprudence. As such, the thinking behind natural law, be it in terms of Socrates, Plato, or Aristotle, was basically that there is a connection which exists between law and morals, and that law must be both just and fair. Now, what this meant in turn was that natural law theorists or jurists believed that because laws or because jurisprudence was supposed to be encapsulated in morals and because it was supposed to be just and fair, man-made law must conform to a higher principle of right conduct, which is discoverable through reason. Now, later on when we discuss natural law, you'll understand how this at one point got shifted into a very religious aspect because we consider these higher principles. Evidently, because of this, you could see that the concept varies from person to person, time to time, and more importantly, place to place as well. Natural law theory developed over time, and we can consider or discuss this concept of jurisprudence under four seminal or four primary limbs. Firstly, the classical period, the Middle Ages, the Renaissance, and the modern period. So let's look at each individual period of time separately. Firstly, the classical period was dominated by the ancient Greeks and the Romans. Socrates, for instance, had considered natural law theory or jurisprudence as having been a product of correct reasoning. You could see this being expanded on by Aristotle, who considered that it's a universal and immutable standard, discoverable through reason, and man-made law should conform to these higher standards. You'll notice that it's at this point that you will see a tangent and a shift taking place as you move forward. Plato considered something similar and noted that the ultimate justice is discoverable through reason. The Middle Ages saw a marked difference or a decline in the study of the Greeks and Romans, and more emphasis being placed on religion and faith. Two jurists or two academics that could be considered as outlining the Middle Ages is St. Augustine and St. Thomas Aquinas. In De Civitas Dei, St. Augustine noted, "What are states without justice but robber hands enlarged?" In essence, we see in the Middle Ages this concept of reasoning, of morality, of just and fairness, which was considered through the period of the Greeks and Romans by Aristotle, by Plato and Socrates, shifting more towards a hierarchy which was religious in nature. So in St. Augustine's De Civitas Dei, you'd note that he considers religion as being paramount to that of reason. This doesn't mean that reason took a back seat. On the contrary, it creates a situation where religion is said to be the reason or the higher power. St. Thomas Aquinas, on the other hand, considered that unjust laws deserve no obedience. He noted that man can find natural law by applying reason and studying scriptures of revelations of God. Now, what must be considered at this point of jurisprudential thinking is that time had moved on to a point where religion played a major part of not just laws but also society at large. In essence, people believed in religious aspects or scriptures as being gospel as well as the higher form that you must aspire to. The contribution in that sense is that what Thomas Aquinas managed to do was, rather than looking at it holistically or solely in the context of religion, he tried to harmonize the teachings of the Greek philosophers before him with the beliefs of the Catholic Church. It was in essence a balance, so to speak. This balancing of interests later on in sociological school of jurisprudence we see in so many other aspects in the future as well. According to St. Thomas Aquinas, law can be considered in four seminal aspects. Firstly, eternal law or lex eterna. This is an aspect of law which is only known to God. Secondly, you have divine law or lex divina. This is a part of eternal law or law that is known only to God, but revealed to men by God through Holy Scriptures. What St. Thomas Aquinas believed was that the highest form of law was that of lex eterna, and what could be understood and manifested by man was revealed to man by God through Scriptures. Thirdly, you have actual natural law or lex natura. This is part of divine law, which is the law revealed to man by God and understood by men through reason. And finally, you have human law or lex humana. This is primarily and intrinsically law derived directly or solely by man. Now, St. Thomas Aquinas considered that man-made law on its own is quite unjust. Why? On the one hand, it furthered the interests of the lawgiver only, because he believed that it was biased to the person who created it. Moreover, he felt that exceeding of power by the lawgiver could occur as well as burdensome on the people that it governed. Now, it must be noted that modern constitutionalism has been heavily influenced by St. Thomas Aquinas even to this day. The Renaissance period saw the revival of the Greek and Roman thinking. So instead of relying on the scriptures during Middle Ages, they started looking at the human element itself, the purpose in itself. The theory of social contract is seen as being given birth at this point by academics or jurists such as Rousseau, Hobbes and Locke. The whole notion of natural law, which we were looking at up until this point, slowly shifted towards the aspect of natural rights. This can be seen as a forerunner towards fundamental rights or human rights. This, in essence, brings us to the modern period, or that which we see in the 19th century. Fortunately or unfortunately, the whole premise and the concepts of natural law, seen originally from the Greeks and Romans to the Middle Ages by St. Augustine and St. Aquinas, to that of the Renaissance period where the Greek and Roman thinking started to proliferate and come back or revive itself by way of Rousseau, Hobbes and Locke, saw a decline, primarily due to A, scientific knowledge which was now more prevalent, as well as different people using natural law for different ends. And this, in essence, being considered by Alf Ross, for instance, as being like a harlot, natural law being at the disposal of many for their own personal gain. The emergence of positivists was another reason, and positivists in turn, an aspect which we will look at later on in another lesson, believed that the role of the jurist was also to analyze the law and not exactly how it ought to be. However, following World War II, for instance, natural law again gathered some acceptance because of the atrocities that happened during that time by Nazi rule. You could see a real-world shift in thinking with the Universal Declaration of Human Rights, for instance. There have been a number of contributions to jurisprudential thought by way of natural law. First and foremost, it has played an important role in establishing moral concepts such as pacta sunt servanda, or for instance, agreements are to be honored. It has inspired the formation of democratic constitutions in the modern world, such as that of the US and France, for instance, and aspects of fundamental or human rights have been encapsulated, especially following the Nazi regime as well as the atrocities of World War II. Principles of equity have been developed through that of natural law. Things which are strict or laws which are strict in the essence of common law have been shifted quite primarily in equity by virtue of natural law precepts. For instance, the Lord Chancellor in the UK at one point of time intervened to reduce these harshness. Development of natural justice, or for instance concepts such as audi alteram partem and nemo judex in causa, these aspects have primarily come into the forefront of jurisprudential thought and legal systems, in essence because of natural law thinking and the jurists that propounded it. That was a quick outline of natural law or the school of natural law thinking. In the next lesson, we will begin our discussion on the seminal and fundamental aspects